Yes, Ms. Hoggett.
Might I ask you to go to page 137 of the core volume?
Yes.
And at the bottom of page 137 is where the relevant part of the judgment of Lord Justice Lewison begins. And you will be aware from our appellant's case that we say a lot of things go wrong in this judgment. There's a confusion in relation to the application of the principles, and the position is also that it overlooks a lot of the terms of the licence agreement and mischaracterises the licence agreement. And it fails to take account of the grant of rights as opposed to the actual usage. Now, first of all, in no particular order, the position in relation to what it granted is that it did not grant any possessory right in the spillway. At the date of the licence, it could not do so. It didn't have, the licensor did not have any rights in the spillway. That was equipment, that was chattels that were owned by the respondent in this case. So the respondent brought the equipment onto the land as its own property, and it had the duty and the power and the right to remove it upon termination.
Became fixed to the land, I think.
It became part of the land, yes. So once it was in the land, it is quite right that it was then our property. But the actual grant, we couldn't grant any rights in the infrastructure. It was not ours to grant any rights in. And it did not purport to grant any rights in the infrastructure.
But it became yours as a result of its construction.
It did.
Why could the grant not work so as to confer possessory rights in it once it was built and became yours?
Well, there were two reasons. The first is a collection of reasons about the terms of the licence as a whole, which I'll go through in a moment. But we say that it did not grant any possessory right, even when it was in the ground. It was our property, the infrastructure at that point. They had no rights in the infrastructure when it was in the ground. It was purely a right of discharge, and the right of discharge wasn't possessory. So the grant, because the question has to be in the grant as opposed to the actual usage, so it can't be de facto. We didn't grant any rights in the infrastructure. We could not do so, and it did not purport to grant any rights.
But the acid test of whether it's yours is whether you could have taken it away.
Yes, and it was our property. So subject to the restriction which the licence brought about on my rights,
Yes.
then it was our property.
Yes, but it would have been a derogation from grant to remove it.
Absolutely.
And you couldn't have done
Subject
so
to
if
the
the court had
licence.
intervened.
Correct. Yes, I agree. Because during the term of the licence, my client, as owner, had restricted its rights by reference to the permission it had granted under the terms of the licence.
And the effect of relief from forfeiture would be to restore the status quo ante only.
The simple, broad question, without going to technicalities, is yes.
Yeah, I mean, after forfeiture, if forfeiture takes effect, then they can take away the pipes and things.
And I wasn't seeking to be difficult in hesitating. It's just that there's some technical history about this, whether it needs to be a re-grant, but I won't go.
Yeah.
You couldn't in fact use it either during the lifetime of the licence, could you? Not for discharge.
Well, can I come
I know there was
to one of
some-
these rights
I know there was
specifically?
some-
I don't agree with that
Okay.
proposition.
Right.
But perhaps if I can take it in stages. The first and principal point that I want to make is that my client could not have done more to ensure that it still exercised full rights and control and that possession was not granted. And let me take you to some examples of that. First of all, if we go through the recitals right at the outset of the licence, which is at 196. The third recital states the purpose of the licence. What is the objective of the licence? And the purpose of the licence is simply a right to discharge surface water and trade effluent. It is not a right to stay there permanently. It's not a right to possess. It's not a right to exclude the world. It is purely a right of discharge. It is not a right of exclusive use in grant. It is not a right of sole use in grant. And I keep saying in grant, not to be pedantic, but that is the critical issue. What was granted? Usage, which is focused upon the Court of Appeal judgment, is not the issue. It's the rights. So there is no right to possession granted. It's simply a right of discharge, which, as we know from the law we've looked at already, is not a possessory right. Why is the appellant in control? Why isn't the respondent in control? Well, if we look at clause 1.2, the appellant can dictate the dimensions and the capacity. So that's entirely within my client's control. That's a factor which Lord Justice Lewison did not mention at all. If we look at clause 1.3, my client can change the route of access across other lands. And if one looks at this provision, which was the access right, the right and liberty for all or any purposes of course to access to spillway along the land coloured blue, or over the adjoining land by such other route as may be from time to time prescribed by the engineer. We can control that. No suggestion of exclusivity or sole use. Clause 3C, if we go to the actual covenants, and that's halfway down page 199, my client has control over the plans. The equipment's to be constructed under the supervision of my client's engineer. Again, all of these features weren't mentioned by Lord Justice Lewison from my recollection.
Well, the engineer had a right to, you had a right that the engineer should give his consent to the plans. It's not quite full control.
Under his supervision,
Yeah.
my lord.
I mean, essentially, Vauxhall would have drawn the plans
Correct.
and the engineer had a veto over them.
Yes. And he could supervise it in all respects. If we then go to clause 3D, my client could require it to be enlarged to a size stipulated by my client's engineer. And if they didn't do it, then we were entitled to do it. Clause 3E, maintenance is entirely to our satisfaction, the engineer again. 3G, to do as little damage or injury as possible to the lands, properties and works of the Canal Company, not to interfere in any manner with the traffic thereon, therefore clearly anticipating traffic in relation to other uses. So quite clearly, no reference to sole use or exclusivity.
Well, the traffic thereon is isn't that the traffic on the canal? Not the traffic in the spillway, is it?
No, no. It's traffic.
Well, what other traffic apart from what other traffic was there on your client's strip along the bank,
Yeah.
rather than going up and down the canal?
Well, to take, for example, clause 1.3, access way. with necessary vehicles, equipment and materials
Yeah, but that's not
along
traffic.
the land on the blue plan.
Surely not traffic.
No, but it's what the traffic's on. So if you look at clause 1.3, there's a right of access, a vehicular right of access. So on page 198,
Sorry, hang on, let's be clear what we're talking. We're talking about G, where they have to do not to interfere with the traffic thereon,
yeah,
and thereon is referring back to the land, properties and works of the canal company. Presumably, so one's talking about any traffic which happens to be going on the land of the canal company.
which is the entirety of the land
Yeah.
over which the rights are exercised.
Yes, that's reasonably clear, isn't it?
But land includes land covered by water.
Not talking about things going down.
Yes, yes. Land is land not covered by water.
Oh, no, sorry, I said includes land covered by water.
It does include land. Yeah, covered by water.
But be that as it may, it's not about traffic on the spillway.
No, but the rights are over the land. The
Yeah.
rights are in respect of the land. One of the rights is a right of access, for example, and that clearly isn't sole usage. And clearly, any traffic which is on our land or our works on that land cannot be interfered with. So again, this all points against any exclusivity or any possession.
Can you just help me though going back? I didn't quite understand what D is about, 3D. Why would the canal company want Vauxhall to enlarge the spillway?
To control the discharge going into the canal.
What, so it goes in more slowly or goes in more quickly? Or
Either, potentially.
it's not to
But it
enable
is.
them to put other spillway into it, and other spillage into it? No,
I can't answer that.
no, I just find that slightly odd.
But it's
Because you can presumably control the flow in other ways than enlarging the canal. It's rather an odd way of doing it. Anyway, if you don't know, don't worry.
all I'm going on is the wording where it says for the purpose of controlling the discharge.
Yes, exactly, but I couldn't see why enlarging the spillway would be an effective means of controlling it, but still.
I suppose it just controls the rate.
Anyway, we don't know and
Yeah.
we're speculating. All right, go on.
So we were at 3G, which again shows that it's not sole, it's not possession.
No. Well, you can obviously go through all this, and that's, you've made your point. If the other five want to say something different, then they don't say it.
Could I just, for the notes, give two other references that I rely upon? Clause 4.1, which makes it quite clear that we can still use all of our land, and our only restriction is in terms of unreasonableness or material interference.
And 4.3a.
And 4.3.
That restricts
Exactly, it's a
them.
combination of the start of clause 4 and 4.3a, which therefore accepts that we are still using it. It's only when it gets to that degree that we are restricted by this licence vis-à-vis the licensee. So it's acceptance of all our rights of usage. That there is only that restriction to that extent. And even in relation to the termination clause, if there'd been possession granted, then why didn't it say re-enter? If it is really going to be a forfeiture clause, why didn't it say re-enter if possession had been conferred? It didn't. It was a termination procedure only. Now, apart from slight inferential references, those rights are not referred to by Lord Justice Lewison. All of the fact that we had managed to make sure that we were still exercising full rights and control and yet still grant a right of discharge were set out in that licence. We could not have done more to ensure that we still had full rights of control and that possession was granted. There is no reference in there to possession. There is no reference to rights of sole use. And inferences cannot be drawn from facts because we are simply interpreting the grant. So looking at the response position in context, they couldn't decide how to use the land. They couldn't decide how to use the spillway. The equipment could only be used for the purposes of discharging water subject to the restrictions. There was no exclusivity in anything. They couldn't even decide on dimensions and capacity. They could be made to enlarge it, and they could be required to alter, divert, modify or reconstruct it. And they could even be moved in relation to the use of the equipment under Clause 3J.
Lord Justice Lewison thought that the rights over the property, coupled with the physical characteristics and other features that you've pointed out for us, suggested that it was clearly the intention of the parties that Vauxhall would be the only entity able to use and maintain the spillway. Do you dispute that as a proposition?
Yes, I do dispute that. What I was going to turn to, actually, was going through each of those sentences in the paragraph to show why they're wrong.
Very good, thank you.
And if I might just find the... it's at page 139 in the bundle. And before I go through each of those sentences, perhaps I can just refer back briefly to page 138 and to paragraph 60, because you will have it in mind from this that we dispute the whole approach. In paragraph 60, Lord Justice Lewison says, in the way the law is developed, it's not necessary the possessory rights be rights in land in order to attract the jurisdiction to grant relief against forfeiture. Possessory rights in the infrastructure, or even in the airspace enclosed by the infrastructure, would, in my judgment, be enough. So just dissecting that, we say, first of all, that has to be wrong as a matter of principle. You cannot get relief from forfeiture in relation to property rights through the back door by bringing a piece of infrastructure on the land.
Yeah, well, you've dealt with that point.
Indeed.
We're now on whether...
Exactly. So the second point of dissection in relation to this is that earlier on in paragraph 58, Lord Justice Lewison, I don't know whether I can draw a full conclusion, but the inference from paragraph 58 is when he refers to the licence, he talks about whether an agreement can be a lease for other technical reasons. So there is no misunderstanding here. We know for a whole variety of reasons, not just a technical reason about the term, that this was not a licence and therefore didn't confer possessory rights in land. So we've got two problematic a series of approaches that then form the backdrop to the sentences in paragraph 67 and 68, which are on page 139. And turning to the first of those sentences, which is the very sentence that Lord Kitchen asked me a question on a few moments ago, the sentence, it was therefore plainly contemplated that Vauxhall would be the only entity to use the infrastructure. And I answered the question by saying that we dispute that. And we do dispute it. And we dispute it because there is absolutely nothing in the grant which confers a right that Vauxhall would be the only entity to use it. And it's the right which matters, the interpretation of the right that matters. The question is, was there a grant of a right of possession? No.
No, but in terms of what he says, it was contemplated that Vauxhall would in practice be the only entity to use it. That clearly was right.
I can't, well,
I mean, who
no,
else,
I
who
don't
else,
accept
who else
that.
is going to use it?
I don't accept that as a matter of right.
No, I mean, that's what he says. He says plainly contemplated that Vauxhall would be the only entity to use the infrastructure. Well, who else is going to use it?
Well, I think where the point lies that I'm trying to focus on is that it's a question of the right.
No, you say that. I
Yeah.
understand you say that isn't a right.
Yeah.
But in terms of what he actually says in that sentence, it's clearly right, isn't it?
Well, it depends what you mean. If the inference is that he's talking about the licence, or if he's just making an observation that he saw fit to make subjectively, then the latter, he may have formed that subjective inference, but it can't be a conclusion about the interpretation of the right, because does that...
Right, well, that's that sentence. There's another sentence you quarrel with.
Yes. So the next sentence is, the physical characteristics of the spillway were agreed between the parties before the licence was granted. Now, I don't think this is material, but I can't find anything to that effect about the physical dimensions having been agreed.
Well, we must assume they were. I mean, you're...
Exactly, where does it take us? Let's go to the next sentence. I'm going through this sentence by sentence because these two paragraphs are essentially his reasoning as to why he takes to view the possessory rights. That's why I need to look at them individually. And so that one doesn't take us to that conclusion. So the next sentence is, those physical characteristics were such that large structures on Manchester Ship Canal Company's land were to be enclosed or buried, and the only physical landward access to the enclosed and buried parts of the spillway was to be from Vauxhall's land. Now, I don't think we dispute that as a matter of fact, but it still doesn't say anything about the grant of the right. The next paragraph, thus the licence cast upon Vauxhall the responsibility for the physical construction of the infrastructure and the sole primary responsibility of its maintenance and repair. Now, the obligations in respect of repair say nothing about possession. Just because somebody has an obligation to repair something doesn't say anything about rights of possession. It is not directed to the right question. What's more, in terms of the word control, or responsibility, it totally overlooks the fact of the obligations which we've already seen. It was always subject to our approval. We were the ones who could dictate the dimensions and capacity. It was always under our supervision and to satisfaction. Even repair and maintenance had to be up to our satisfaction in all respects. So it does not represent the actual position under the terms of the licence, and it omits to take account of all of the control in other ways that could be exercised by my client. The next sentence, it did not reserve to Manchester Ship Canal Company any rights to use the infrastructure or, except in case of default by Vauxhall, to carry out works to it. Now, this is a really pertinent point, because, of course, the law generally is that if you need to reserve it, then you've actually given possession. So the fact that there's no reservation supports my client's position, because it shows that it did not give over possession. It did not need to reserve anything to itself. And it, again, fails to take account of the fact we could require complete removal. We had a full right to use all our surrounding land. We retained control over the usage of the spillway. Then the next sentence, those rights over the physical property, coupled with its physical characteristics and the clear intention that Vauxhall would be the only entity able to use and maintain it, amount, in my judgment, to a sufficient degree of physical custody and control of the infrastructure, although not the soil in which it was placed, having regard to the nature of the property and the manner in which property of that character is commonly enjoyed. Vauxhall plainly intended to exercise those rights and fulfil those responsibilities on its own behalf and for its own benefit. The combination of those elements means that the rights granted by the licence were possessory in nature and thus open the way to the exercise of the equitable jurisdiction to grant relief from forfeiture. Now, the reality of the situation was the infrastructure, once it was in the land, belonged to us. They did not have any grant of a right of possession of even the air. I mean, who's to know how much the spillway would be used? And it's an irrelevant question, the extent of usage. It was simply a flow of discharge. A flow of discharge is not possessory. They can't even say they had possession of the pipes, because that was our property. They weren't possessing even that.
Yeah, well, I think we've got that point. I mean, you say that all these things are no doubt may well be true, but they don't add up to possession in any sort of legal sense.
I'll move on.
No.
So
If you're
paragraph...
right on that, then you're right, you win the case.
Paragraph 69 I'll move on to then.
Well, that's the 1977 variation, which
It's, yeah.
doesn't make any difference.
And the first point which is said about this, the variation can't have retrospectively altered the nature
Well, I
of
mean,
rights.
if it wasn't, whatever the position was before, the 1997 variation is not going to change it, is it?
Well, as a matter of law, a variation changes things from the date of the grant. So as a matter of law, that sentence is wrong. That's what a variation does.
Well, I know it does, but in terms of the overall picture of this case, it's hardly going to be the tail that wags the dog.
And of course, the deed did affect the position in two particular ways. Firstly, of course, it granted my client a right to discharge water onto the respondent's land. So on any view, our water from that date was going through the pipe under that variation alone. Now, the other variation was clause 2, whereby it accepted that the licence could now be assigned to a greater body of persons, legal persons, who could have rights in respect to the use of the spillway. So again, we get to this complete contradiction is that here we have an assignment permission for others to use it. And it is still said, well, the sole use, and therefore it's a possessory right. When here we are with absolute categorical permission, and we now know that permission has been acted upon, for others using the spillway. And it's not just a matter of usage, they have been assigned rights. There is a transfer whereby Vauxhall assigned, by way of a transfer, their ownership of part of the land which they owned at the date of the licence. And in that transfer, and it's in the trial bundle, they assigned rights under this licence. They assigned their contractual rights under this licence for use in common with Vauxhall. So not only is the grant not sole and exclusive, the usage isn't sole and exclusive. And this is why this is all such a real contradiction.
Give me a page reference for that last point.
The transfer point.
Yes,
The transfer isn't in the bundle before this court.
Right.
The assignment itself. We referred to that. It was in the trial bundle. It was referred to in the Court of Appeal, and the other side did not take any issue with our reference to it as an assignment. Would you like to see that transfer?
Just give me the Court of Appeal paragraph again, please.
We're in paragraph 69 and we're on page 140.
My understanding is that the Vauxhall transferred bits of land
Yes.
which had previously been served by the spillway. And not surprisingly, therefore, when they transferred the land to others, they transferred that right to use the spillway to drain it to the same persons to whom they transferred the land. And that's, have I correctly understood what those transfers are about?
Effectively, you might describe it as a partial assignment of rights under the licence.
Yeah, so they weren't
Using
extending,
common.
if you like, the dominant tenement. They were simply dealing with a situation where the original dominant tenement, I know I'm using easement language, was split up to make sure that those who came to own bits of it also had the relevant rights.
Yes.
Yeah,
Yes.
okay.
But what I think it's inherent in your question, and forgive me if I'm therefore repeating, I don't want to annoy anyone by repeating myself, but therefore it's so obvious from that we''ve got lots of different users and we've got different persons entitled to the rights under the licence. We have not even got a situation on the ground of sole usage, and we don't have a situation under the grant of rights of sole usage.
Right?
I was just wondering whether Lord Briggs...
I think you've made your point.
You made your point.
Right, have we dealt with that?
Yes.
Can you just help me on one thing in relation to clause 5 of the licence? I mean, although we've obviously been concentrating on its use in the case of failure to pay, the clause itself, which is on MS page 206, extends to any breach, doesn't it?
Yes.
So any breach of any kind can result in an obligation to make reasonable compensation and remedy the same capable of remedied. Now, do you say that there's no power to relieve against forfeiture in those circumstances?
Yes,
Either.
I do. I say no jurisdiction under any terms of this
I mean,
licence.
the court could decide whether they've made, whether it's capable of being remedied, for example, couldn't they? That's a perfectly justiciable issue.
I don't accept there's relief from forfeiture on any of these terms, whether it was be a breach of covenant or a non-payment.
So an issue might come to court as to whether they have breached the terms and so on, but
And whether there
court would
has
have
been
no power to grant relief.
where there's been accrual and crystallisation of the right to terminate, do you mean? Well,
Yes,
yes, I agree.
I see.
And indeed, there was an expert
Although,
determination.
it does look extraordinarily like a lease forfeiture clause, doesn't it?
Well, I would disagree with that observation, respectfully, because it doesn't have the words forfeiture, it doesn't have the words re-entry, and that's critical. It is simply a notice procedure to terminate. So it's actually much more akin to a pure contractual rights termination provision as opposed to a forfeiture clause. It's simply, and you can test it by way of practical application. The rights are simply terminated. There's no physical act required. There's no re-entry required, which demonstrates our point that no possession has been granted.
So when you say, when Lord Justice Lewison says it mirrors that of a forfeiture clause in a lease, you say no, because it doesn't contain the word re-enter?
We've said quite a few things, and that is one of them. We've referred to the termination procedure and how it operates. It's simply not at all like a forfeiture provision. It is simply contractual.
And you say you've dealt with that. Is that covered in your case?
We dealt with it in detail in our skeleton argument at first instance. And so it isn't detailed in the appellant's case. No.
Well, never mind. I don't want to get bogged down in it. It's not the key point. Okay.
So, before I move on, I just want again to look at the overall scenario in relation to this licence. And the question which was put earlier on today in relation to the licence, which seems to have stood out as the primary feature in Lord Briggs's questions to me, was the word perpetual and a reference to the possessory scenario in that context. And I just want to address that by reference to what we've looked at in the other rights we've just gone through. Because you will have seen from those other rights that this is a position of very great control by Manchester Ship Canal. All of its rights in relation to usage of the land, no grant of possession, no grant of sole usage, huge rights of supervision and control and approvals, etc., etc. And so we don't accept that there's anything unusual in a perpetual licence, or there aren't many of them, as I understand the position. But the critical thing is, again, the difference that we can't compare a perpetual scenario of the cases about indefinite possession in chattels with that on land. Because, yes, in terms of time, although it wasn't very far removed from a periodic licence, which might not have been renewed on breach, we accept the word perpetual. But that doesn't give rise to ownership, because that is maybe forever, but it's only forever in a very, very precarious way. It's fragile. Now, when you get to chattels, the big difference is that chattels have a limited time usage. And this is very important, because land is always going to be there. So when it comes to the rights and regulating the rights of the parties, here, it's a precarious scenario. There's not very many rights granted to Vauxhall, simply a right of discharge and the ancillary rights to actually build the spillway to make it, facilitate that right, and a right of access for it. Everything else is still very much under the control of Manchester Ship Canal, who can still use all the land. And that's forever, whatever perpetual means, subject to the right of termination. When you get a chattel and you're giving over possession, a chattel has a relatively limited period of time. And when we looked at those cases earlier, possession was being given over, so they had full rights in relation to that period for which the chattel might be described colloquially as being alive and having a useful existence. And from the case we saw, there was also right to ownership at the end of its useful life. So you can see why that in that situation, the indefinite right to possession for a chattel which has a short space of useful existence, and you have a right to ownership at the end, is very much more of an ownership right than here, where all of those rights that we've just looked at are so controlled by my clients and are so small in simply being a right of discharge and ancillary rights, are always quite limited rights. They are not ownership, they are not possession. And they'll never get any better.
Yeah. But I think we're going back over the ground now. I'm concerned that you've not got very much time left, particularly if you're going to end well within time. What's left of the issues then?
There's just one issue left, my lord, yeah. And it's the issue about the spillway in terms of the forfeiture of the spillway. And you've already, already heard from me of two integral features in relation to this, that you can't confuse relief from forfeiture in relation to chattels with the real property forfeiture, and the fact that were no rights granted into the spillway. But the separate final point that I have on this is that there was no forfeiture of the spillway. They had to take it away. And
In bits and pieces and a collection of completely unusable rubble, presumably. You couldn't just lift it up and put it down somewhere else where you could use it.
No, but, my lord, I hope you don't mind if I don't accept that factual
Well, I may be quite
description.
wrong, but that's how it looks
just
on the
going with
plan.
it for a moment, given that we are concerned with the rights here, the relief and forfeiture is only in respect of rights. We always have to look at the actual contractual scenario. And how can it be right that you confer relief from forfeiture in relation to land by reference to principles regarding personal property when you didn't grant any rights in that personal property at all? You couldn't, and you didn't. And what's more, that personal property has to go at the end of the day.
Yes.
So I'm not taking anything back.
Yes. I mean, this is your point, that the right relates to the flow of the water. It doesn't relate to the things through which the water runs. And Lord Justice Lewis, in effect, treated them as part of the same thing. So, and you said that's wrong. I understand that.
The respondents,
Yeah.
just to elaborate very briefly further on this point, my lord, don't seem to have any answer to that point in my submission.
Good. Well, that's very helpful. Is that it?
I'm very conscious of your remarks. I think you have my...
No, I don't want to hurry you up unnecessarily, but I think we've got the general picture very helpfully. And you've got a reply anyway, so
Thank you very much.
thank you very much, Solomon. Yes.
My Lord, our answer to that
And
last
Miss
point,
Ward, do you follow?
our answer to that last point is in MS page 98, should you need it.
MS page 98.
Yes. But
Are you coming back to that, or do I need to look at it?
you don't need to look at it. And may I explain how Mr. Edwards and I are going to approach our oral submissions?
Please, thank you.
Because unlike my learned friend Miss Holland and Mr. Edwards, I don't claim to be a proper land or property lawyer. My role hitherto has been to look at the history of the Canal, look at the 1885 Act and the claim under it that both courts below have rejected,
Yes.
to look at the history of the acquisition of the site, the grant of the licence, the exchange of land which enabled Vauxhall to build its effluent plant and gave the Ship Canal Company a slightly larger area of land on which it would build its railway if it chose to.
Yes.
I've looked at the circumstances in which the £50 annual rent came to be unpaid in October 2013 and was terminated in February 2014.
Well, you're telling us there's lots of stuff which we're not interested
I am, but I'm just telling the court that if any of those issues arise, and they seem not to do so,
Yes.
I'm here to help. Otherwise, what I'm going to do is to introduce and summarise our submissions
Yes.
on the issue raised in this appeal. I'm going to leave their development and any difficult questions to Mr. Edwards. And at the end of my summary, which will be 10 or 15 minutes,
Yes.
I will look at the geography, at the pipes, at the plans, at the spillway,
Yes.
and at the photographs, simply to explain what it is we're talking about here. And to make this process manageable, I've a short speaking note that you may find it easier to have in front of you as I speak. I've got copies for your judicial assistance
Well,
as
hand
well.
it round, but you're saying it doesn't deal with any of the difficult issues.
It deals with them perfectly, but in summary.
I see. Well, let's have that, and Mr. Edwards is happy that he's going to take on the major burden.
He is. He and I have agreed that I will do the introductory session, and I have some references that I'll add to this note as I take you through it.
Right, thank you.
As you'll see, it is short.
Thank you.
So because I needed to inform myself of the history, I needed to look at the origins of the jurisdiction, and we can see that the equitable jurisdiction to grant relief from forfeiture was well established by the 17th and 18th centuries and originally developed in parallel with the court's jurisdiction to relieve from penalties. That part of the history is set out in the Cavendish Square Holdings case, and we do emphasise that it continues to share common features with that jurisdiction. We submit that the jurisdiction now very clearly extends to real and personal property in exactly the same way, I add to the note, albeit the limits of it have never been precisely defined. But we identify certain clear principles which have emerged in the jurisprudence, and we firmly support the orthodox approach of the Court of Appeal to relief from forfeiture, which we've dealt with in part 1 of our case, and I identify 4 of those principles. First, it's clear and key that the termination clause in question must be inserted to secure compliance with the obligation to which it relates. That takes us back to Peachey and Somerset in 1720. That in turn requires the court to focus on the original intent of the parties in drafting that clause, a point with which Miss Holland dealt, and you need to ask if the parties intended it to act in the way which it did, which we say it does, as a forfeiture clause. Now, contrary to Miss Holland's characterisation of our argument, that doesn't need to be the sole purpose of the clause in question. We pick up Lord Wilberforce's speech, his judgment in Shiloh Spinners at page 723 of the report, MS page 761, and at the bottom of the page, between letters G and H, Lord Wilberforce says that it has to be the primary object of the bargain. And that is the characterisation we have used and prefer. And it was indeed the primary obligation of the clause here. And we see that recited perfectly in the Chancery Division judgment and in the Court of Appeal. If I may give you the references. In the Chancery Division judgment, paragraph 96, page 170, MS 170. And in the Court of Appeal judgment, paragraph 70, MS 140.
But I mean, surely we just look at the clause to see what it was intended to do.
Yes, it was intended to secure...
It was clearly intended to secure the enforcement of the monetary obligation.
And the other obligations.
And the other obligation.
I agree.
But I mean, what other purpose did it have?
No. That was its purpose. That's what made it a forfeiture clause.
Yes, and why are we worrying about primary and non-primary? I mean,
Our argument was characterised as sole purpose. I'm characterising it in accordance with Lord Wilberforce's formulation as primary object. Second, the jurisprudence establishes that the jurisdiction does not extend to rights and property, whether real or personal, that are merely, using that adverb advisedly, contractual. Thirdly, now clearly established in the authorities, that the orthodox approach to this jurisdiction covers rights which are both or either proprietary or possessory. And fourthly, contrary to the new case the appellant puts forward, which we answer in part 2 of ours, there is no good reason why the jurisdiction should apply any differently to real as opposed to personal property. It would be illogical and, we submit, inconsistent with the jurisdiction's historical origins, as well as its more recent development and application, especially in relation to penalties. See Cavendish Holdings. Applying the orthodox test, then, we submit that what was granted under the licence here were indeed possessory rights. With respect to Ms. Holland this morning, it's not a concept we find troublesome at all. Those were either possessory rights in the actual spillway, which Vauxhall had to construct, maintain, and of which, as the court has found, it had exclusive use and control, And the references to that, may I add them to the note? In His Honour Judge Behrens' judgment, at paragraphs 90.4, 94 and 95, at MS 170, that's where he made the findings of fact about exclusive use, which are followed in the Court of Appeal at paragraphs 68 to 70 at MS 140. Or alternatively, as possessory rights in relation to the infrastructure and airspace enclosed by the various elements of that infrastructure, as Lord Justice Lewison set out at paragraphs 60 and 68, MS 138 and 140.
Taking it, the judge concentrated on the first point rather than the second point about airspace and infrastructure.
Yes. And we emphasise in my paragraph 8 of this, or sorry, paragraph 6 of this note, in every aspect of the analysis, equity looks at substance, not form. And the substance of this agreement, we submit, was the grant of rights which were truly possessory. And the only possible departure that we canvassed from the orthodox analysis was one that we also commended to the court at first instance, and do so again now in part 3 of our written case. It's that even the limitation of the equitable jurisdiction to rights that are strictly proprietary or possessory may no longer be appropriate, something that was contemplated in the extract from Snell that we drew to the court's attention at first instance, and in Dr. Turner's very recent Cambridge Law Journal article, which we've included at tab 51 of volume 3. So on that basis, even if one were to find that the rights under this licence to build, use and maintain the spillway can't be characterised as strictly possessory, the court's wider jurisdiction still extends to the rights that we actually had.
And in that respect, you presumably invite us to reinstate the judge's slightly broader view,
yes,
in preference for that of the...
Yes, he used a language that was also used by Lord Justice Robert Walker in the on-demand case about possessory character.
Did on-demand reach the right decision in your case?
Well, that's a question I think that I file under difficult and for Mr. Edwards to deal with in due course. With no disrespect, Your Ladyship.
I'll take that.
It is his area of expertise. And he would prefer it too. But we would submit that this wider approach that we've looked at in part 3, would we say be consistent with principle and not inappropriately innovative. We don't seek to extend the jurisdiction to mere licences, because we can see the logic of some limits of principle to an equitable jurisdiction, but we find those in Shiloh's spinners, and we've set them out there. They're the familiar ones of the right to forfeit must be inserted to secure the payment of money, which this certainly was, or at least that was one of the purposes of its insertion, or there's been fraud, accident, mistake or surprise, and those, as we know, Lord Wilberforce's words that Lord Duplock sought to qualify in the scap trade. Now, as I've already said, the present case comfortably satisfies the first of those two tests, and it would follow that regardless of whether the contract was in relation to real or personal property, there was every reason for equity here to intervene to relieve Vauxhall of the otherwise catastrophic commercial consequences of a minor and easily remediable contractual breach in failing to pay £50, a consequence which, as we say, can be characterised as truly penal. If you're going to look at the figures that we saw at first instance, you'll find these in the Chancery Division judgments. There's a wrong reference there. CB 180 should be MS 179. And the figure that Mr. Davis came up with in March 2014, the month after the licence was terminated, was just under £600,000. It could have been over 600, or indeed even more, since what MSC charged on its book of rates depended on their own scales, the size of the outfall, volume discharge, pipe size and area drains and other variables. And going back to the question you asked about why you might want a larger outfall, the answer is that the greater the area over which you disperse the outflow, the less impact there will be on the canal itself. So not causing any adverse currents in the canal to the disturbance of shipping, and less likely to cause erosion of the banks. In a nutshell, then, we entirely reject the submission that this perpetual, I add that word, licence to paragraph 10, granted no more than a mere right to drain water from dominant servient land. We submit the obligations imposed on Vauxhall here and the consequential rights they enjoyed went well beyond that, and particularly the obligation to build and maintain this very substantial spillway with its pipes and structures, coupled with the exclusive use of it and rights and obligations to use it in accordance with the licence, did indeed create possessory rights in a strict or orthodox sense, as the Court of Appeal held, or alternatively it creates rights which, whilst perhaps not strictly possessory, nevertheless engage the equitable jurisdiction on the wider basis we set out in part 3. I turn to the plans in the hope that it is helpful.
Can I just ask you, the point against you taking a sort of simple view of this is that your clients back in 1962 entered into a document which was described as a licence, and clearly they would have been aware that they weren't getting a full easement or any proprietary right. And they were also aware that it was subject to the ability to, if they didn't pay their, what might seem a pretty cheap rent, they were at risk that they would find themselves clobbered and have to pay a market rent. Now, that was a commercial decision they made to take that interest. Why should we relieve them now?
Yes, reduced to its simplest terms, Malone and Friends' case is people called it a licence, licences grant no rights, but...
and in the context of property, she says, everyone understood what that meant. I mean, if I can get sort of bogged down in relation to personal property, but in relation to real property, we all knew what that meant. Well, why should we...
There may be reasons why there was a preference for a licence rather than a lease or the grant of an easement. They thought it was an equitable easement at some stage because they sought to register it as such. And there are good reasons why it wouldn't have been sold as a freehold. Maybe that it was more readily enforceable with covenants in this form, but we're speculating about that, to be absolutely candid. Don't suppose for a moment we could have any confidence in saying what the parties had in mind with regard to potential relief from forfeiture. But the fact is, as Mr. Edwards will explain, the clause they've come up with here is, as the courts below have held, very close to what you would draft as a forfeiture clause.
Okay, well, anyway, I just put that point to you, and no doubt Mr. Edwards will have more sophisticated answers to it.
Well...
No, none.
None.
But you put yourself forward as putting the overview, so I put...
I did, and with justification.
Yeah.
He will.
Good, I
sure.
look forward. That's the end of your bit, is it?
Yes, but I'm going to look at the geography.
Oh, yep.
Otherwise, it is, you say, the end of the overture. But it would be helpful to look at the geography. And may we start, please, with page 222. Which learned from Miss Holland took you to, and is the land as it was at about the time that the licence was granted after Vauxhall had acquired the red hatched area, the rhomboid at the top, which includes the whole of the trade effluent plant, and the whole of Vauxhall's land, as we see it there, amounted to just over 370 acres. Photograph on 342. The bottom photograph showing the Mersey, the ship canal, and in the centre of the picture you can see the rhomboid, which is the developed area, the effluent plant, in amongst the greenery of the trees.
Yes.
342. And the Mersey, obviously a strongly tidal stretch, quite where the previous original owner of Hooton Hall, Mr. Naylor, moored his yacht in so tidal a water before it was cut off. We'll never know. It can't have been very close to there. But the effluent plant is the developed area you can see within the greenery just to the right of the blue of the canal as we look at it. If you turn to next to 329, shows the land titles as they now are, including the supplier. Red and beige is Vauxhall's land, now just over 300 acres. The other land, the green bit, is the Hooton Park Trust, otherwise it's the supplier park that you can see there. Next, 219, if you please. This is the exchange of land plan that Ms. Holland took you to.
Yeah.
We, Vauxhall, sell them or exchange the pink land. It doesn't matter, but the pink land is actually the 6.8 acres that the judge referred to at first instance. The land we get is 2.88. It doesn't matter. But so green is the land we get from Vauxhall, from the Ship Canal Company. Pink is the land that the Ship Canal Company gets from us. If you look, and I'm not asking you to do this, if you look into the details within the exchange, you'll see a reference to a 48-inch and a 72-inch drainage pipe, which cross that pink land and takes water into the effluent plant area. And that we'll see in a moment. If we go to, there was also, because the Ship Canal Company was getting more land, they were getting 6.68 acres and we were getting 2.88. The Ship Canal Company paid just over £9,000, which is provided for in the exchange to balance the books, as it were. If you come next to 210, MS 210, this is the plan of the land and the spillway as annexed to the licence. And the definition of the spillway, you will find, I'm just going to give this as a reference for you, the definition of what's included by the spillway. And in fact, the spillway includes all the pipes that extend from Vauxhall Motors land across the Ship Canal and into the outfall. Spillway is defined in clause 1.2 of the licence, MS 197. And it's also in the Chancery Division judgment at page 162 of MS, paragraph 35, and page 198. If you look carefully at the lower of those two plans on 210, you'll see the blue pipe, which is an 84-inch pipe, 2,100 millimetres, running from the effluent plant, which is the boundary of Vauxhall's land, running underground to a distribution chamber, which is in the lower part of the hatched area. And originally, because it was anticipated that a wharf might be built on the side of the canal here, originally it was envisaged that the spillway might have two strands to it, one going off to the west, one going off to the east. In fact, only the eastern one that you can see there is the one that was actually built. And from the distribution chamber, which is where the blue joins the hatched pink, you'll see that the that the pipes are there are two 66-inch 1675 pipes which go to a single wide outfall that I'll show you in the photographs in a moment.
And this is of some interest, but is it actually helping us with the legal issue?
It is put no higher to you than if it's helpful to have an idea of the geography. I'll show you the photographs if I may. I'm putting it no higher than to say it is of some interest, and it won't take a moment. If you don't mind going to page 216. The interest in it really is to see the extent of the spillway and to understand the very considerable piece of infrastructure that we're engaged in. So 216 is looking towards the North Road, and there on the left of the top photograph is the 72-inch.
Sorry, I'm 216 in my bundle. Is a lot of
It's
text.
completely my fault. I was looking at the wrong internal numbering. I meant 337. 337.
Yes. So what are we looking at there?
72-inch pipe on the left, which is the one that drains Vauxhall's land. The 48-inch pipe on the right, which now drains the supplier park. And then it comes through, and we call that the head wall. It then runs down some steps you've got on page 338. Down through the ravine, you've got at 338 and 339. The ravine itself is 117 metres long, 3 metres deep. At the end of the ravine, you're on page 340 now. There's what's called a stilling basin. So the water comes through into the stilling basin from the ravine, which is on the left of the upper photograph in 340. It's not through that elephant's trunk. If you look carefully at that photograph, you can see some disturbed water just beyond the elephant's trunk at a lower level. That's called a penstock valve. And when the water gets to a certain height, it opens the penstock valve and flows through into the stilling basin. So from left to right in the upper photograph. And then the lower photograph of the stilling basin, also called a distribution chamber. The ravine's on the right, so it's then flowing out through an 84-inch pipe. And those pipes, not quite as per the diagram, it doesn't matter, you can see at page 334. Isn't in fact the hexagonal chamber, but it doesn't matter. And having gone to the hexagonal chamber in the centre of the plan, it then runs off, as we've seen on the plan to the right, to the outfall, which you have at 332. .335 and 341.
At which point in the photographs do we leave Vauxhall's land?
We leave Vauxhall's land a little beyond the photograph that you have at 219. So if I can help you by looking at the diagram at 331, this diagram comes up in various places, but if you go to 331,
yes,
and almost all of these references, can I give you the references where you'll find them in the judgments? Transfer Division Judgment, paragraphs 35 to 44, MS 162, Court of Appeal Judgment, paragraphs 16 to 26, at MS 159. So the pipes in the head wall are at the bottom. They're indicated by a letter F on the diagram at 331, which was the one appended to the judgment. The ravine is 117 metres. The outflow from the ravine through the penstock valve into the, what I've called it, the stilling basin. The stilling basin here is shown as I, letter I. At the far end of the stilling basin is the 84-inch pipe. And to answer my lady's question, the distance from you can see the hatch line marks the boundary of Vauxhall's land. The experts agreed, it's not in the judgment, but it's at page 576 in the experts bundle, if anyone wants to look at it, that it's 35 metres from the canal end of the Stilling Basin to the hexagonal chamber, and it's then another 15 to 17 metres to the outfall, and the hexagonal chamber itself has 6 walls, each 5 metres long. I'm not going to correct some of the annotations on the photographs because I hope I've explained it sufficiently.
So can I make sure I understood this? The only bits of all this structure which are within ship canals are the 84-inch pipe, the hexagonal chamber, and then the pipe that takes you down to the outfall.
The two pipes to the outfall and the outfall.
Pipes to the outfall and the outfall.
Yeah.
All the rest of it, the ravine, Stilling Basin, the head wall and everything else is all within Vauxhall.
Exactly so. And the definition of the spillway includes those elements that your Lordship has identified rather than our ravine and so forth.
Very small point. Is it hexagonal or octagonal?
Well, it's hexagonal according to what the learned judge found.
It's depicted as
what the experts had agreed.
Right. Very well.
But I take your point.
Yeah.
But we've always referred to it as the hexagonal chamber.
I mean, are we allowed to refer to it as octagonal?
Well,
It'd be quite helpful to get it right.
Well, the experts, we're assuming this is exactly correct. It may be better to refer to it as a hexagonal chamber, which we all have done to date.
Even
It
if
is,
it's not.
I think
Right.
it is hexagonal on my plan. On 331.
Well, page 331
Oh, no,
is
maybe.
not hexagonal.
Okay, no, I think you're right.
But, right, so are we agreed that it is in fact octagonal, although it's always been referred to as hexagonal?
We aren't necessarily agreed this is a precise representation of it as drawn, so I ought to say that. I'm happy to call it either. What we do find in the Court of Appeal judgment at paragraph 26, the Court of Appeal does say 6 walls, each 5 metres long, which they get from the trial judge. So
Well, we better take what
I think we should, if I may say so, take it at that and think that perhaps.
And looking at page 331, the red letters refer to the numbers at the top of the following pages, which have the page.
Yes, but they're not precisely accurate.
Yeah, they're not
reasons
precise. They give you a general idea.
explain, but they're intended to. The one that's slightly misleading is if you look at 212B, the suggestion is that's the hexagonal or octagonal chamber. That's actually, the top one is the Stilling Basin, and the lower one is looking back towards the Stilling Basin from behind the grill at the front of the pipe.
But for our purposes, probably the important point is the one that was put to you by my Lord Briggs about the extent which is actually within the ship.
It is. So you've got the distances, and the pipes, you'll appreciate, go underground to the hexagonal chamber.
Yeah.
The hexagonal chamber itself is partly below ground and partly above ground, and then run underground again to the outfall, which you can see above ground.
Right, well, thank you very much. It's very helpful.
As a matter of interest, the effluent includes the 3 items on the right, does it? At 331, A, B and C. And general drainage, probably.
Spillway. So, I'm sorry, my lady.
And general drainage. Acid and alkali discharge from the paint unit.
Yes, although I think it should be clear that from the mid-1960s on, trade effluent was drained by an entirely different process. So the only thing that drains through this spillway is surface water running off impermeable land and any residual land which gets into the ravine naturally. But otherwise, effluent goes into the general drainage system. Or there's anything else on the facts,
Thank you.
the summary and introduction.
Right, well, thank you very much. And so we're now over to Mr. Edwards.
may I first take you to Shiloh, Spinners and Harding for a few more moments look at that, because that's, I suppose, where all this started.
Yes.
And that's at MS 728, tab 15 in the paper, core or primary authorities bundle. We all know that this was a slightly unusual case in that it involved a situation where there had been an assignment of a lease, and the assignor wanted to secure obligations on the assignee to carry out works of fencing and so forth, and wanted to reserve a right to re-enter onto the assigned land in breach of those fencing and support obligations. There was a lot in the case about whether that was a registrable interest or not, with which we're not concerned. But it's important, I submit, or we submit, to know what led up to what Lord Wilberforce said. And here, slightly unusually perhaps, I'd like to take you to some part of the argument. If we go to MS page 739 and letter D, in the argument of the respondents, leading counsel being A.J. Bolcombe, later Lord Justice Bolcombe, and he was against, so speaking, against the applicability of a right to forfeiture. And he said this: courts have no jurisdiction to relieve against forfeiture by re-entry.
Right, where are we now?
Just between letters C and D, where number 4.
By which page? I'm
MS 739.
739 or 729, sorry.
739.
And you say this is Mr. Bolcombe rather than Mr. Weinlot.
I beg your pardon, it is Mr. Weinlot.
Yes.
And it is indeed Mr. Weinlot. Later, Mr. Justice Weinlot, of course. He said, the courts have no jurisdiction to relieve against forfeiture by re-entry. Relief falls into 2 main categories. The case of a creditor in respect of a quantified sum of money, when relief may be given because the land is only security. The courts also relieve against forfeiture for non-payment of rent, regarding the land as a mere security. Under this head, there is no general jurisdiction to relieve against forfeiture for breach of a covenant. Courts of equity have always had jurisdiction to relieve in the case of fraud, mistake, accident or surprise, but these categories were always very narrow, and the courts have never relieved in cases of mere inadvertence or forgetfulness or a fortiori, willful breach. Historically, there was a period in the 18th century when the court would relieve against a breach of condition by a lessee to keep fences in proper repair, even if the breach were inadvertent or forgetful. But in Hill and Berkeley, these cases were overruled. So what was at issue was whether or not there was a residual jurisdiction to relieve from forfeiture outside that which statute had provided in Section 146 of the 1925 Act in cases other than non-payment of money. That was the issue before the House of Lords in this case. Namely, was Hill and Berkeley right? Was it the last word barring statutory intervention? Because we know Section 146 provides for relief from forfeiture in cases of leases otherwise than for payment of rent, covenants otherwise than for payment of rent. I just want to take you then to Mr. Bolcombe's submissions at page 747, letter G, which neatly frame the argument. and it's just below G as to question 5, relating to relief from forfeiture. The general equitable principle is that relief will be granted whenever adequate compensation can be made for breach which gave rise to the forfeiture. If this had been a landlord and tenant case before the legislation of 1925, the respondent would have been shut out. Before the decision of Lord Chancellor Lord Eldon in Hill and Berkeley, the courts of equity had relieved against forfeiture in such cases, but he damned the stream. The point has never been before the House of Lords, which should now restore the stream. So those were the arguments, and
interesting that they had 8 days of argument in that case, so they had time to develop.
Yes, and so that, if you like, is why we get to what Lord Wilberforce said in his speech, MS page 760, letter A. There cannot be any doubt that from the earliest times, courts of equity have asserted the right to relieve against forfeiture of property. The jurisdiction has not been confined to any particular type of case. And then he says what the commonest types were, and then he continues. Although the principle is well established, there has undoubtedly been some fluctuation of authority as to the self-limitation to be imposed or accepted on this power. There's not been much difficulty as regards 2 heads of jurisdiction. So he goes on then to
I'm sorry, I'm on the wrong page. Which page are you on?
760.
Thank you.
So he then goes on to set out what on the face of it, are 3 separate heads of jurisdiction for relief from forfeiture. First, where it's possible to state that the object of the transaction and the assertion of the right to forfeit is essentially to secure the payment of money. And this goes back to the argument we saw. Equity has been willing to relieve on terms that the payment is made with interest if appropriate and also costs. Yet even this head of relief has not been uncontested. And we see that the Lord Chancellor, Lord Eldon, in Hill and Berkeley, expressed his suspicion of it as a valid principle, pointing out in an argument which surely has some force that there may be cases where to oblige accept to sort of stipulated sum of money, even with interest at a date when receipt had lost its usefulness, might represent an unjust variation of what had been contracted for. I pause there. Lord Eldon was obviously very much in the school of jurists who valued above all the freedom to contract. And then he goes on. Secondly, there are the heads of fraud, accident, mistake or surprise, always a ground for equities of intervention, the inclusion of which entailed the exclusion of mere inadvertence and a fortiori of willful defaults, echoing almost precisely the words in his argument of Mr. Weinlot. And then, so those are the 2 established areas as Lord Wilberforce saw it. And then he went on to consider the debatable area in which were included obligations in leases such as to repair and analogous obligations concerning the condition of property and covenants to insure or not to assign. And it was with that residual jurisdiction that Lord Wilberforce was then concerned, and in respect of which his words were then directed. And we submit that it's important to bear that in mind. That is because he then goes on, and I'll skip the rest. We've read this, I'm sure, any number of times now. But if we go on to page 761, letter E, he continues, as regards the present appeal, it is possible to disengage the following considerations. In the first place, there should be put on one side cases where the courts has been asked to relieve against conditions contained in wills or gifts into vivos. These raise considerations of a different kind. Secondly, no decision in the present case involves the establishment or recognition, directly or by implication, of any general power That is to say, apart from the special heads of fraud, accident, mistake or surprise, in courts exercising equitable jurisdiction to relieve against men's bargains. And then he cites Lord Eldon's views. But it is and then we get to the key words. It's consistent with these principles that we should reaffirm the rights of courts of equity in appropriate and limited cases to relieve against forfeiture for breach of covenant or condition, where the primary object of the bargain is to secure a stated result, which can be effectively be attained when the matter comes before the court, and where the forfeiture provision is added by way of security for the production of that result. And then he goes on to give a little bit of help as to what he means by the word appropriate. And of course, those are discretionary matters. And the important thing to bear in mind about those discretionary matters is that they're, by very long established principle, there is no such discretion in relation to payment of rent. Even if you deliberately fail to pay rent, you pay it up, plus interest, plus cost, you get your relief from forfeiture. Not so in relation to the third category of relief from forfeiture, where you're considering covenants more generally, such as to repair, to insure, not to assign. A classic one, of course, which we've all studied as students, not to use for immoral purposes. We have there, therefore, a third category, which Lord Wilberforce is enunciating. And in our submission, it's important to bear in mind that there are these three separate categories. There still are these three separate categories. And his words, appropriate and limited, were referring to the third category. That is not to say that Lord Wilberforce was supporting a general jurisdiction to relieve in relation to men's bargains, because he says in terms that he wasn't. He was talking about relief from forfeiture of property. So and this echoes very much what my learned friend Miss Holland said at the outset. What we are talking about is someone losing something. Something they have, they lose. And the question is always, and it's always going to be, well, what is that something? Is it of a sufficient quality or character that the jurisdiction should be exercised, but always with the precondition that the termination provision in question has been inserted with the primary object of securing compliance with an obligation. So that I submit gives a background to Shiloh, Spinners and Harding and what we can take from it. And what we take from it, I submit, is that the word appropriate it has no real bearing on our instant case because it's a payment of money case. And the word limited was more directed in when he was speaking about this third category of case and not necessarily the case of payment of money. Can I now turn to the scap trade? And again, in the scap trade, I submit it's useful for us to look for a moment or two at the argument when it got to the House of Lords. And that the scap trade is MS page 717, tab 14 in the paper bundle. And there's only one little bit of the argument that I want to take you to. And I want to take you to it for this reason, that my learned friend has speculated that Lord Diplock got his phrase possessory, proprietary or possessory, simply from considering a previous decision he'd made about a charter party, and simply because we were dealing with ships, not land. Well, in my respectful submission, the argument again doesn't bear that out. And in this case, it was all on one side, because in respect of one part, the respondents weren't called on. The argument is at page 719, and we see that it was advanced by no meaner jurist than Johann Stein. We see at letters B to C this short passage, which I submit is absolutely illuminating. The owners suggest, and this is at MS 719 between letters B and C, the owners suggest that the following characteristics of a time charter take it outside the scope of the equitable jurisdiction. Save for penalties and forfeitures of money, the doctrine is limited to forfeiture of some proprietary or possessory interests in land, such as a lease. B, no forfeiture is involved. C, the obligation to pay hire promptly in advance is a condition of the contract. And D, the commercial nature of the contract. And so, right at the heart of the submissions before the House was this concept of forfeiture being limited to proprietary or possessory interests in land. I don't know where Mr. Steyn, later Lord Steyn, got that formulation from. And I only draw it to your attention, my lords and ladies, because it sets the scene for what Lord Diplock said thereafter. In other words, it undermines, fatally I would submit, the submission that Lord Diplock was somehow just inadvertently introducing into the language of the relief from forfeiture.
But I mean, we don't know where Mr. Steyn got it from. I mean,
We don't.
He wasn't famous as a property lawyer. He was famous for the other things.
Indeed, he was not.
No, I mean, I personally, I have to say, find this concept of possessory interest in land very difficult, because it doesn't sort of, because we get involved in these very odd discussions about what it means. And one's conscious of it being used in certain contexts, but as a general proposition, decided when you can or cannot get relief, I find it pretty unsatisfactory.
Well, I'll be coming to that, obviously, because that's the central issue in relation to the new case advanced by the appellants, and also...
I think both of you, in a sense, find it quite difficult, and so Ms. Holland sort of narrows it down to interest in land. You sort of broaden it out.
Yes.
And maybe we'll have to decide which of those we like.
Well, our submission is that we would broaden it out simply because it is right so to do. It is not necessary so to do. We would submit that the concept of a possessory right in land is perfectly simple and plain, and I'll develop that submission if
Anyway, not necessarily because Mr. Steyn QC used it, but because it
Well,
has other virtues.
No,
So shall we move on from that?
I will indeed. And if I can take you really to the next little snippet from, this time from Lord Diplock's
Yes.
speech, and that is at MS page 723, and where he says, this is a passage we've already looked at, just between letters G and H. A time charter, unless it is a charter by demise with which your lordships are not concerned, transfers to the charterer no interest in or right to possession of the vessel. So, in other words, when Lord Diplock was talking of possessory rights, it was just a synonym for rights to possession of, and no more. And then we, of course, get to the part where Lord Diplock, and then at MS page 725, was commenting on Shiloh, Spinners and Harding. At letter C, he talks about the mainly historical statement never being meant to apply generally to contracts not involving any transfer of proprietary or possessory rights. In other words, transfer of property or right to possession, seen in the light of his previous remark. And as I say, I would submit that it is plain that when, in the light of the submission that had been made to him, or to the House, I should say, that it can't just have been because he was talking about a ship and not land that he used that phrase. Now, the concept of possession has, for a number of purposes, assumed very central role in this appeal. It has two crucial importances. One, in relation to the Court of Appeal's decision itself. In other words, in its own terms, was the Court of Appeal right in relation to deciding whether possessory rights were granted or a right to possession was granted in relation to the infrastructure. And then in relation to the new case advanced by the appellant, which says, well, we should rule it out entirely in relation to the issue of jurisdiction to relief from forfeiture. Now, I mean, it's fair to say that this didn't form any part of the case in the Court of Appeal, and it didn't form any part of the case when the matter came before no, it was my Lord Briggs, I think, was involved.
Well, it doesn't matter.
It doesn't matter, anyway. However, one part of the appellant's case, which I would like to take you to, or the grounds of appeal, in fact, more accurately, if I can take you to those, it's in MS 20.
Sorry, MS?
MS 20.
This is their notice of appeal.
Yes.
Do we need to go back to that?
Well, in my respectful submission, yes. Can I just, in fact, I'll just take you to one small part in the notice of appeal at MS 24, paragraph 20. And I take
MS 24.
MS 24, paragraph 20. And I take you to this because, partly because of the way the appellants have put their case, namely to extend, as they see it, relief from forfeiture to possessory interests in land would disrupt property transactions, and partly also to start, if you like, my answer to the question, my lord, you posed to my learned leader. It says this: property transactions have long been entered into on the footing that transactions granting proprietary or possessory rights will give rise to a claim for relief from forfeiture, but purely contractual rights will not. Parties who have entered into such licenses with contractual terminations provisions will not previously have appreciated the relief from forfeiture may be found available in such cases. Now, it may be that that's open to interpretation, and it may be that what I submit here is a simple rhetorical flourish. But if that is the understanding, that property transactions have been entered into on the basis that relief from forfeiture is available in relation to proprietary and possessory rights, then what is the mischief that the appellants are seeking this court to correct? I would submit there is no such mischief. And the reality is that, as this passage in my own friend's grounds of appeal says, that lawyers have understood that the right to relief from forfeiture is available for proprietary or possessory interests.
No, but I mean, I'm not quite sure what the point you're making, Mr. Edwards. The point Ms. Holland's making is that, and she makes this very clearly in paragraph 13 and 14 of her case here, that leading textbooks on land will say that forfeiture is available to a tenant but not a licensee.
Well,
and someone in 1962 entering into a thing called a license with full advice would certainly start arguably from the proposition that forfeiture doesn't apply to it.
well,
And he probably wouldn't have known anything about these subtle arguments we've had about possessory or non-possessory.
Indeed, of course, in 1962, they wouldn't have even had Shiloh, Spinners and Harding to go on, because that was decided in 1972.
Yeah. We haven't looked at the textbooks in 1962,
well,
and we don't want to. But all I'm saying is there is a valid point which you have to meet, that the expectation in property context, in the real property context, might well be that a license would not attract the consequences which Section 146 of the Law of Property Act mitigated by reference to leases.
Well, in my respectful submission, one textbook does not a consensus make. You have seen...
Of course it doesn't, but that's the point being made. It's being made there's been an understanding that licenses are not within the scope of forfeiture, and what's been said is this will create uncertainty.
Well, in our respectful submission, that has not been the consensus, and we can see that quite clearly, partly from what as he became Lord Steyne, submitted to Lord Diplock in the scap trade, where he submitted directly to the contrary, and partly also from the way in which the courts have adopted that as, if you like, the standard and accepted definition. And we can see that not only in what Lord Diplock said, not only what Lord Justice Dillon said, and we've seen that in BICC and Burnley, and the relevant passages are of course, in the Kukavara, which we go to in the primary authorities. And it's at MS pages 496 and 497. Firstly, we start with the passage we've already seen from what Lord Justice Dillon said in BICC, PLC and Burnley Corporation, where he's dealing with whether relief from forfeiture should be available in relation to property other than land. And he says relief is only available where what is in question forfeiture of proprietary or possessory rights, and continues, but I see no reason in principle for drawing a distinction as to the type of property in which the rights subsist. So that's a situation then. And then at paragraph 94, that reasoning with which the board agrees supports the conclusion that relief from forfeiture is available in principle where what is in question is forfeiture of proprietary or possessory rights, as opposed to mere contractual rights, regardless of the type of property concerned. So again, that completely endorsed what Lord Justice Dillon said. But it's not only there that we find that. We find it in the case of Bland, which we haven't yet looked at, which I think is in volume 2. And yes, sorry, it's tab 3, MS 423, 410, thank you, MS 410. And here we have the Court of Appeal, Norse, Chandwick and Hale, as she then was. This concerned a property in relation to which a charging order had been made under the Land Charges Act 1972. That act provides that such a charging order is the equivalent of an equitable charge made under the hand of the owner. And the land in question was a lease, and the lease was of a commercial premises, restaurant, and rent was not paid, and peaceful re-entry took place. And the question then arose whether, on their own application, the beneficiary of the Land Charges Act charge could seek relief from forfeiture. The answer was no, directly, but an indirect route was found to save them, in that it was held that they could get the relief indirectly by joining the tenant as defendants to the action and get under the court's inherent jurisdiction relief against forfeiture. So that's a rather convoluted background. And the passage to which...
But that must have happened entirely under the umbrella of the statutory regime, wasn't it?
It was... The eventual decision was that they couldn't come within the statutory regime, but they could, by an indirect route, take advantage of the court's inherent jurisdiction. But 31, I mean, it's of not the precise decision is of no real consequence or importance for our purposes, except at paragraph 31 in the judgment of Lord Justice Norse, who said this: while I sympathise with the feelings of Mr. Justice Warner and Lady Justice Butler-Sloss, I don't think it's open to us to give them effect. A jurisdiction doesn't become discretionary just because it is both inherent and equitable. The authorities show that the cases in which the inherent jurisdiction to grant relief against forfeiture for non-payment of rent has been exercised have been restricted to those in which the person claiming relief is entitled to possession of the land, or at any rate, which is not necessarily the same thing as a legal estate or equitable interest in it. So that was the view of Lord Justice Norse in a case which did concern interests in land, although what he said was obiter, because it wasn't part of the ratio decidendi of the case. But what it does show is that Lord Justice Norse in 2001 considered quite clearly that the jurisdiction to grant relief from forfeiture in relation to land extended not only to cases where the person claiming relief had a legal estate or an equitable interest in it, but also was entitled to possession of it. So, my Lord, I answer the question that was posed initially to my learned leader well, it's a license. They must have understood that they could not apply for relief from forfeiture in this way. Well, the common law, or in this case equity, develops in a developmental, incremental way. That license was entered into, in fact, before Shiloh, Spinners and Harding. If they had been asked then, well, is this a forfeiture clause? Will relief from forfeiture be available? Well, we have no idea what they might have said. It's right to say, in fact, they might have well have said yes, of course, in that way related to implied terms, because we do know as a fact that they registered it as an equitable easement, and so. But what they thought and what they believed are, in our respectful submission, nothing to the point. What you have to consider is whether now the jurisprudence having plainly moved on since 1961 or two, not least because of Shiloh, Spinners and Harding, the jurisdiction to relief from forfeiture should draw a distinction between property which is real property and property which is any other sort of property. And we see in the judgments of a number of very eminent lawyers who, well, I know Lord Justice North, for example, he must have been aware of the difference between real and personal property. He must have been aware, he quite plainly states it in relation to land, that here it is, this is a jurisdiction which is available where the person claiming relief is entitled to possession of the land. And that I submit is a very, very strong indication, along with the indications given in the Kookaburra by the judgment of the board approving what Lord Justice Dillon said in BICC and Burnley, that there is no basis for saying that the way in which this has been put in the cases is accidental, that it is come in somehow by the back door, that it's in some way unprincipled, that it will give rise to uncertainty. In my respectful submission, there's nothing in our respectful submission, there's nothing in any of those arguments whatsoever. In terms of certainty, why is there a greater need for certainty in a transaction concerning land than a transaction concerning any other sort of property? In fact, we see, because the citations shows this, that certainty in commercial transactions was one of the key submissions made against the extension of the right to relief from forfeiture to property other than land. And we see that in scap trade going one way, we see it in celestial aviation going one way, but going in wholly the different direction in the on-demand case. Now, my learned friend says certainty in land is greater, the greatest need, the greater need, but the only authority she manages to cite in support of that suggestion is, as I understand it, from the Ashburn and Stout case, which is in the primary authorities bundle at tab 1, MS 349. It's in the judgment of just check. I think it's Lord Justice Fox. Yes.
Which page do you want us to go to?
MS 374, letter E.
Thank you.
And this is cited in the applicant's case. In matters relating to the title of land, certainty is of prime importance. Well, yes, but we're not dealing with title here. Nobody's impugning title to land here. And so, in my respectful submission, there is no logical distinction to be drawn in terms of the need for certainty between real property, land, and any other form of property. Indeed, there may be pressing reasons why certainty points the other way, in that, as has been pointed out, chattels are ordinarily wasting assets, whereas land ordinarily, although not necessarily, is not. And thus, in our respectful submission, in relation to an asset which is wasting, the need for certainty is likely to be more critical, because time will reduce its value. Whereas in relation to land, well, time can go either way. It can lead to its value going up, or it can lead to its value going down, but it's not so much of a wasting asset. So, in my respectful submission, there's nothing in the argument about certainty that should persuade you to say that the relief from forfeiture should only be available in relation to real property where there's a proprietary interest. What about the argument that possession is and I'll end on this as I see it's 5 to 4, is a difficult concept, one that is hard to pin down. In my respectful submission, that's not so. We for the purposes that we're dealing with today, Lord Justice Lewison gave a perfectly adequate, well, I shouldn't say that, a definition with which we can all work. And we see that in his judgment, in the core volume, where he deals with this at MS 138, paragraph 59, and sets out a definition of possession derived from PI, which, as my own friend Miss Holland rightly says, dealt with adverse possession, limitation of actions. However, and in closing today, I would just draw your attention to the fact that that definition has been happily adopted by Mr. Justice Morgan.
May I just ask, where is that derived from? It's not Pye and Graham, is it?
Yes.
Oh, it is, that,
Yes.
the definition, right.
Yes. And Pye and Graham is in the bundles, the authority should
Well, it's not
my
just
lord
from Pye and Graham, is
need to
it?
look at it.
It's not just from Pye and Graham.
No, not just from Pye.
And the concept of possession in fact and intention to possess is very seated.
Indeed, but the concept of possession in land law is absolutely critical. It's central to title, in fact. And I'll perhaps pick up on that theme tomorrow morning. But I just want to close by drawing your attention.
There's all those cases about whether someone's gone out of possession resolved by...
Yes, I'm not going to draw your
animus
attention
possidendi.
to one of those yet, but I will come to them, albeit briefly. It's a topical case involving a Mr. De Vere, and it's at MS 1116, I think. In fact, it starts at MS 1098. It's a judgment of Mr. Justice Morgan, London Borough of Housing against Mr. De Vere and others. If any of you were watching BBC London News last night, you will have seen Mr. De Vere because he is still moored at Brentford Dock, and the London Borough of Hounslow is still seeking to evict him. The means by which they are attempting that now is by bylaws, but that's, if I may say so, by the by. But if I can take you very briefly, just for the purposes of illustration,
I mean, this is just for the context of saying who can bring an action for possession.
That's right.
So, yeah,
But
there it is, we've got it.
there it is, but if I can take you to MS 1116, paragraph 55, and if I can just ask you to glance at that, just to bear out the point that what Lord Justice Lewison said about what amounts to possession is wholly uncontroversial, well established, and not difficult at all.
That's the end, is it, for this
Well,
afternoon?
it is that's it for this afternoon, yes.
Thank you very much. Can I just say one thing? I'd be quite helped if tomorrow you could take us to clause 5 of the
Yes.
licence, and the point that Lord Justice Lewison touched on, but didn't make much of it, the extent to which it appears to be modelled to some extent on section 146. I mean, the way it deals with non-rent faults is, you know, when they're capable.
It's almost word for word.
So someone seems obviously to have had section 146 in mind.
Yeah.
I don't know whether that helps you or is against you.
Well,
But it does seem to me an aspect of the case which deserves little attention.
It helps to this extent to answer the rhetorical question about what the parties might have had in mind.
Yes, but I mean, one point which you might have been making, but aren't, I'm not sure whether you are, is that whatever else you say about possessory and however you apply it in other contexts, you have here an agreement which is for a perpetual right, which is, and where you have a clause which is closely modelled on section 146, which, as far as one can see, is solely there to ensure enforcement
Yes.
of rent and the other terms of the contract. And so it may be that if you were trying to say what the test is in property law, you would make it quite narrow.
Well,
for the purpose of this case.
in many respects, that's exactly what the first instance judge did.
Yeah.
And-
What I'm wondering is, do you need to go as far as to introduce a rather woolly test about what is possessory? I mean, you say it's not woolly, but isn't it possible that we could be deciding this case on a much narrower basis?
Well, I certainly don't need to succeed on my argument or our argument that it's wider still than possessory.
Anyway, I'm just putting that thought into your
Thank you.
mind,
Yeah.
and indeed Miss Holland's mind for tomorrow. So how are we? Are we on course for
Oh, yes.
what? How much longer do you think you need?
I doubt whether I will need the full hour and a half allotted.
Well, I assume not. You had an extra 20 minutes when you started, so I assume You're well
I
within. And I'm hoping you'll do as well as Ms Holland did in terms of...
I fully intend to keep my remaining submissions to within an hour.
Right, thank you.
Volume-wise, just the answer to my Lord Kitchen's point is it was indeed a hexagonal chamber. There's a later diagram which we'd actually originally intended to add to the bundle, which shows 6
Just don't have a very good draftsman in that particular diagram.
Well, thank you. We're very...
diagrams.
On that happy note, we'll
A cheerful note on which to end.
10:30. Ms Holland, you...
Well, Manolo Junior just raises the question of Lord Bruce's article.
Oh, yes, did you want to see it?
Would that be possible?
I'll who shall I send it to?
Should I provide an email to the...
Yes, if you send me an email, I will return it and then you can distribute it.
That would be most kind. Thank you very much.
Necessary participants. I don't think you'll find it either enlightening or anything else very much, but I thought I ought to mention it.
Good, thank you very much. See you 10:30 tomorrow.